Hello everyone, welcome to Courts Today by Live Law, your one-step destination for the latest and fastest legal updates. I am your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. The biggest news in the country today is the gruesome rape and murder of a second-year postgraduate medical student at RG Kar Medical College in Kolkata. And why not? The horrific crime has shocked the nation and each day brings more disturbing details. Not only about the brutality of the crime, but also about the alleged attempts to tamper with the crime scene and protect the real culprits. The entire state of West Bengal is up in arms with widespread protests demanding justice and questioning the handling of the investigation. The Calcutta High Court bench of Chief Justice T.S. Sivangnanam and Justice Hiranyamai Bhattacharya was today hearing multiple pleas, including one by the parents of the victim in this case, seeking transfer of investigation to an independent agency. The court today questioned the lack of preventive measures to curb the large-scale vandalism and violence which occurred at the hospital on the night of 14th August. The state replied that the police put up resistance but were overwhelmed by the 5,000 to 7,000 strong mob who broke through barriers and injured several policemen. The bench said that normally the police always have an intelligence wing. If 7,000 people were to gather, it would be hard to believe that the state police did not know. The court said that curfew orders under Section 144 of CRPC are passed for any reason, but when so much commotion is going on, the police should have cordoned off the entire area. The bench significantly stated that it was an absolute failure of the state machinery. In its order, the court noted that although the place of occurrence of the crime was saved from the attack, it would be imperative to provide safety to the doctors and nurses working in the hospital to ensure that they were able to carry out their duties with a sense of security. Also last week, the High Court transferred the investigation into this incident to the CBI. Upon noting that the state police had not been proactive in the investigation of the incident and the state administration was not with the victim or her parents. Also, let me tell you, the People's Union for Civil Liberties has also approached the Calcutta High Court now over the incident, praying for a court-monitored investigation and seeking a compliance report on the part of the West Bengal government in implementing the provisions of the POSH Act, that is, Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act of 2013. Do comment and tell us about your views in the comment box. In the next update, the Supreme Court has held a hospital in Ernakulam, Kerala responsible for deficiency in service after it mistakenly handed over the body of a deceased patient to the wrong family, who then cremated the wrong body. The case was heard by a bench comprising Justice Hema Kohli and Justice Sandeep Mehta, who were addressing cross appeals from both the complainants and the hospital. The complainants, whose father's body was wrongly given to another family, had initially been awarded a compensation of 25 lakhs by the Consumer Disputes Redressal Commission. However, this amount was later reduced to 5 lakhs by the National Commission. The Supreme Court disapproved of the National Commission's decision to reduce the compensation and reinstated the original award of 25 lakhs. The court emphasized that there was serious breach of responsibility by the hospital, acknowledging the immense emotional distress caused to the family of the deceased due to this grave error. BJP leader Subramanian Swamy has filed a petition in the Delhi High Court regarding the issue of citizenship of Congress leader Rahul Gandhi. To give you a short background, in 2019, Swamy had written a letter to the centre on alleged violations made by Gandhi in voluntarily disclosing to the British government that he is a citizen of British nationality, amounting to holding a British passport. Swamy had alleged that Gandhi, being an Indian citizen, had violated Article 19 of the Constitution, read with Indian Citizenship Act. According to these, no person shall be a citizen of India or be deemed to be a citizen of India if he has voluntarily acquired the citizenship of any foreign state. A notice was sent by the central government to Gandhi then. Swamy had also written that a company, namely Backdrops Limited, was registered in the UK in 2003 with Gandhi as one of the directors and secretary. He further alleged that in the company's annual returns filed in the year 2005 and 2006, Gandhi's date of birth was given as June 19, 1970, and that his nationality was mentioned as British. Now, Swamy has approached the Delhi High Court seeking a direction on the union government to file a status report on his complaint against the Congress leader. Swamy has said that despite many representations made to the central government asking for an update and status of his complaint, no action has been taken. The plea is likely to be heard next week. For your information, I must also tell you, in May 2019, the Supreme Court had dismissed a plea to restrain Rahul Gandhi from contesting the 2019 general elections until determination of the dual citizenship issue upon his supposedly procuring British citizenship. The Delhi High Court today restored the mandate of the Ad-Hoc committee appointed by the Indian Olympic Association or IOA in December last year for overseeing and taking over all the activities and management of Wrestling Federation of India or WFI. The Ad-Hoc committee was dissolved by the IOA in March this year after the ban on WFI was lifted in February by the United World Wrestling. Justice Sachin Datta held that dissolution of the Ad-Hoc committee was unwarranted. However, the court held that it shall be open to IOA to reconstitute the Ad-Hoc committee so as to ensure that the same is a multi-member body comprising of eminent sportspersons or experts who are well versed in dealing with the international federations so as to allay any concerns that the UWW might have as regards the steps taken qua the WFI. The court passed the order on a plea moved by wrestlers Bajrang Punia, Vinesh Fogart, Sakshi Malik and Satya Rawat Kadian, seeking a direction to the union government to not revoke the suspension of Wrestling Federation of India. And now an update on the suo motu case taken up by the Kerala High Court to prevent and manage natural disasters in wake of the recent Wayanad disaster, where due to heavy rainfall and landslides, more than 230 people lost their lives. The Kerala High Court has sought information from the state government about other vulnerable areas in Wayanad that are prone to natural disasters due to heavy rains. The division bench comprising Justice A.K. Jayashankaran Nambiar and Justice Shyam Kumar V.M. orally stated that news media has reported that due to heavy monsoon, there are other vulnerable areas which are prone to natural disasters. The court thus sought information about such vulnerable areas and stated that there should be continuous monitoring to prevent any such natural disasters. The court further stated that the government should also submit weekly updates regarding rehabilitation activities taking place in Wayanad. It said that it also requires scientific information regarding the cause of landslide. The court has impleaded the Ministry of Road Transport and Highways, National Highway Authority of India North Zone, Central Water Commission, Indian National Centre for Ocean Information Services and National Remote Sensing Centre in the case. Also, let me tell you, the government has submitted that there is an estimated loss of rupees 1200 crores in Wayanad and also submitted data regarding missing persons and injured persons. It appraised the court that the district administration has buried 53 unidentified bodies and handed over 178 bodies to the families. It was also appraised that 212 body parts were recovered from the landslide area. The government further submitted that 3 bridges, 2 schools, 1.5 kilometer road and 2 transformers were destroyed in Wayanad as per the available data. The state government submitted before the court that they would submit a detailed report before the court about the loss and damages incurred in Wayanad. The Gujarat High Court has issued show cause notice to the state forest authorities for their failure to adhere to court directives aimed at preventing Asiatic lion deaths caused by train collisions near the Gir sanctuary. This was after amicus curiae advocate Dharmesh Devnani submitted a report detailing 2 lion deaths due to passenger trains near Amreli. The report revealed that despite prior assurances, necessary measures such as proper fencing, underpasses and cautionary notices for the railways regarding lion presence was still not implemented. Reducing train speeds or improving locomotive headlights was also not done. The division bench consisting of Chief Justice Sunita Agarwal and Justice Pranav Trivedi expressed concern over the lack of critical safety measures. The court also criticized the Chief Conservator of Forests Wildlife Circle, Junagadh, for omitting an incident dated 18th July this year involving deaths of a lioness and 2 cubs in his affidavit despite its coverage in the media. The court also noted inadequate responses from the Railway and Forest Department officials regarding lion deaths from train collisions and ordered them to address these concerns before a high-level committee. The next hearing has now been scheduled for 30th August, requiring strict compliance with the directions. And lastly, coming to important clarifications by the Allahabad High Court with respect to the new criminal laws. The High Court has observed that in a particular case, if the FIR is lodged on or prior 1st July 2024, that is the date of commencement of the 3 new criminal laws, for an offence committed before that date, it would be registered under provisions of Indian Penal Code. Still, the investigation will continue as per Bharatiya Nagrik Suraksha Sanhita or BNSS. The court also held that in a particular case, if the investigation is pending on 1st July 2024, the investigation will continue as per the CRPC. However, the cognizance of the police report will be taken as per the procedure laid down under BNSS. The court also clarified that in such a case, all subsequent proceedings including inquiry, trial or appeal would be conducted as per the BNSS procedure. A bench of Justice Vivek Kumar Birla and Justice Arun Kumar Singh Deshwal was dealing with an FIR quashing plea filed by a person and 4 other accused persons booked in the alleged rape case. In this case, the FIR was lodged on 3rd July and contained provisions of the Indian Penal Code. The court had previously questioned the Hamirpur Superintendent of Police for not applying BNSS provisions in the 3rd July FIR, despite a directive clarifying that investigations should follow BNSS procedures for offences committed before its enforcement. The SP explained that since the alleged incident occurred before 1st July, an FIR was not lodged under the BNS but IPC. Finding the personal affidavit and the reasoning given therein satisfactory, the court went ahead to explain the legal provisions. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.